Alina Shoutsova, immigration attorney from New York, is here. And we're going to talk about United States immigration. We're going to talk about the most recent immigration news. I'm going to share with you some updates regarding removal proceedings. For example, of course, I'm going to mention situation with Russia and Ukraine and what people can do to bring their loved ones to the United States. Absolutely. I'm going to talk with you about great news, not the bad news, for special immigrant juveniles, right? And of course, I'm going to share with you some tips regarding VAWA cases and interesting situation with those who receive adjustment of status in court. Well, first of all, I wanted to mention that United States announced they will hold off on physical deportations for people from Ukraine, Russia, Belarus, Georgia, Hungary, Moldova, Poland, Romania, and Slovakia. It means that if you have an order of removal already and you're from one of these countries, it's probably going to be a good time for you to request a work permit, okay? Because if you know that someone who has an order of removal in the United States and subject to physical deportation that can be enforced against them, they can get an order of supervision in the United States and receive also permission to work. It's very important. Very important. It also means that if you're in the middle of your removal proceedings, you perhaps may use this situation to, depending on what stage of your proceedings you're at, to ask for maybe administratively close your case or for some prosecutorial discretion. It's very, very important to know that. So it does not apply to every country in Europe, but to these 9 countries that I mentioned. Okay, very, very important news. Of course, that what the United States is doing right now for the people who are already in the United States subject to removal in the United States. Now I wanted to mention something that may be helpful for those who have relatives in Ukraine and what to do, how to bring a person from Ukraine currently to the United States. We have very limited options so far. So far, we have non-immigrant or immigrant visa. And to get that visa, you will need to have an appointment at a U.S. consulate overseas. Since it's not possible now to have appointments in Ukraine, the person will have to find their way to a neighboring country, Poland, Germany, Hungary, Turkey, and make an appointment for a non-immigrant visa. The tough situation shows that, unfortunately, appointments are being given months from now. This is something you need to know about. Some attorneys report that if you check with the consulate on a regular basis, you may find an appointment that is faster than the dates I'm going to announce right now. But as of 2 days from today, Germany was scheduling appointments for June and early July. Czech Republic was scheduling appointments for September, and Turkey was giving appointments 2 years from now. Now, this information may change depending on what steps the Department of State is going to undertake to perhaps streamline these appointments or provide more appointments availability. But this is where we're at right now. You may also explore an option of humanitarian parole, Form I-131, that may be filed by anyone for anyone overseas. By the way, it's true not only for people from Ukraine, people from other regions that are affected with any type of conflict or natural disaster may also use this opportunity. I regularly publish information about humanitarian parole on my Facebook page, and there is a good article on my website. Form I-131, there is a fee to it. You also need to submit forms showing that someone is going to be responsible for the person financially while they're in the United States. Affidavit of support, Form I-134, usually should be attached together as long as statement as to why a person needs humanitarian parole. So these are limited options. Of course, you always can explore option of asylum. However, you need to remember that to request asylum, a person has to be either in the United States or they have to be at the United States border, point of entry. And asylum is not suitable for the situation when we're talking only about the conflict, armed conflict. Asylum always has to be connected to a protected ground, which would be nationality, race, place of origin, particular social group, political opinion, and religion. This is what I wanted to talk about Ukraine. Again, not only helpful for people from Ukraine, also may help those who are in other regions where there is unfortunately difficult situation, conflict, and war. Okay. Now I'm going to talk about good news. Good news for those who have special immigrant juvenile status, who are planning on filing for special immigrant juvenile status, or who are pending, whose applications are pending, who filed for special immigrant juvenile status. Special immigrant juvenile status is afforded or potentially may be given to children in the United States who are under 21 at the time when they submitted their applications and petitions with USCIS, who may demonstrate that they were abused, abandoned, neglected, or there was a similar situation, similar basis, by one or both parents. For example, a person whose father, mother, one parent passed away may be able to qualify for the status as well, because it will match similar basis qualification for special immigrant juvenile status. It's not possible to file for the status while a person is overseas. They have to be in the United States. They must be under 21 when they're going through the process. They must first go to local family court, and family court has to make these findings. Findings that the person is unmarried, under 21, that they were abused, abandoned, neglected, or suffered on a similar basis from the hands of one or both parents, and it's not in a person's best interest to be returned back to their home country. Many people do not know about this status, and I ask you to please share this video so more people will learn about this. That if you are in the United States by yourself, under 21, if you can show that your parents or parent abandoned, neglected, or abused you, you will be able to get a green card in the United States potentially. No asylum is necessary. It is not necessary to be in removal proceedings. Only for this particular status is not important if you claimed U.S. citizenship. Well, the waiver is available for most of the grounds of inadmissibility. Only for this particular status, it doesn't matter if you crossed the border or came legally, if you are a child. Very, very important. Well, we have a couple of more reliefs, but this is what I want to talk about. The fact that children in the United States have an opportunity to build up their lives here and receive status. Meet kids all the time who did not know about that, who overstayed their visas. Now they're maybe 22 instead of 20, or they're 21, and it's too late for them to file for it. You need to know about this opportunity. So currently USCIS is changing their rules a little bit, and they will be giving employment authorizations to those kids who filed for the status, for the petition for status itself, but could not file for adjustment of status, and hence could not obtain work permit while the applications are pending. Very important. While the applications rather are waiting to be current. Very important information would be relevant for nationals of such countries as Guatemala, El Salvador, for example, Honduras, where there is about 4-year backlog for the children who are waiting to receive green cards based on special immigrant juvenile petitions. So the United States is improving their policies with regard to those kids, and it's extremely important information for those kids, because you see, we have a lot of different information that may be relevant to different groups of immigrants, but little by little we see there are improvements for certain groups, not in immigration reform right now, but still little improvements that do make a huge difference in lives of certain groups. Very, very important. And of course, I wanted to share with you some tips. I just, as I have consultations with different people, I've noticed that there is a lot of misinformation and confusion about certain situations. For example, I wanted to mention to you something about VAWA, Violence Against Women Act. When you're filing for VAWA, and if it's VAWA based on abuse by your spouse, you do not have to file for divorce against that spouse. There is a misconception that you must be divorced in order to file for VAWA or in order for the VAWA to be granted. This is not the case. You may still even reside together with that spouse. The law does not require you to move out from the common shared residence for you to be able to qualify for VAWA. This is very important. Okay. However, if you are divorced from the abusive spouse, you're going to have only 2 years from the time the divorce became final to file for VAWA. All right. So I hope you will find, or some of you will find this information helpful. No need to file for divorce at all, but if you are divorced, you have 2 years. And finally, we'll share with you a very useful tip for those of you who are filing or received adjustment of status in court. So you see, when you're filing for adjustment of status with USCIS, if your interview goes nicely, if you had an interview, USCIS is going to send you your green card, right? But what's going to happen if it is the judge who orders adjustment of status? What's going to happen, and how are you going to get that green card if you went through the court proceedings and now the judge made a ruling and granted you adjustment of status? Well, USCIS website says that you're supposed to receive the green card, I think they say within 3 days after the immigration judge makes a decision to grant your status. But this is not the case in practice. And I'm going to tell you what you need to do to get the green card. Because if you're not going to do anything, you're not going to receive it. What you will have to do currently is that you're going to have to call USCIS customer service and make a request for an appointment at the local USCIS office. Most likely what's going to happen is that during your call, you are not going to receive any date. You're going to receive a message that a USCIS customer representative is going to contact you back within a certain time, and you will have to wait for their random call. It's very stressful, but this is what they're doing now. You will need to be ready for the 72 hours usually after you called them to receive that magic phone call. Once you receive the magic phone call, USCIS is going to follow up by email with you with a date and time of your appointment. You're going to come with your passport, 2 passport style photos, and prove that the judge granted your adjustment of status. And you're still not going to get your green card. You're going to receive a stamp in your passport. It's good for travel, it's good for employment, it's good for everything. But the green card, hopefully, you're going to receive about 3 to 4 weeks after that appointment. I think this is one of the best advice you could have received today, because many people are confused about what to do in this situation, and I really hope that someone will find this information helpful and will resolve this limbo situation when the court gave them status, but the green card never came and they do not know what to do. So please share this video so someone else will be able to benefit from it as well. And so thank you very much for watching, guys. Please like, share this video. Follow me on this Facebook page, and also please join my YouTube channel as well. And hopefully we're going to get some good news about immigration very soon that I will be happy to share with you. Thank you very much for watching, and I hope to see you soon.